Well, it is Thursday and I am in the office. It is the day before July 4th, the July 4th holiday. So we'll be closed tomorrow, but we'll be available for our clients in the event that there's a call. The 4th of July Day holiday is always a busy time for a lot of criminal defense lawyers because unfortunately people are out and about sometimes drinking and driving. Cars are stopped and as traffic stops, things are found. And we do get calls both in Pennsylvania and New Jersey. With that said, I did put out a blog article regarding some current events. Most people are talking about the Sean Combs trial in New York. Definitely a win for the defense. Not make any kind of political statements here, but definitely a win from the defense standpoint. He was acquitted on the racketeering charges, and he was acquitted on the sexual trafficking charges, found guilty of the prostitution charge under the Mann Act. And I did a blog article on a couple things in the case. His attorneys, as I thought they would, did file a motion for bail following trial as he was acquitted. It would be deemed a change in circumstances, which would make a bail motion appropriate. Whenever a bail motion is made, the first question that judges have is, well, counsel, what has changed? Why are you asking me to reconsider bail? And one of the easiest arguments to make is that charges have been dismissed or dropped or you've been acquitted. Acquittal is actually the best case. In this particular case, he was obviously acquitted. He's still facing jail time, but far less serious charges. His attorneys likely argued that he's not a flight risk despite having large amounts of wealth. He would surrender his passport. Obviously, strong contacts to the community. I don't think he has any prior criminal history that's substantial. But the prosecution, however, successfully got the judge to deny the motion. I was shocked by that turn of events. Normally, I thought that he would be released on $1 million bail or $10 million bond or what have you, and he would appear for sentencing in October. But he's going to stay in jail until October sentencing. He could receive a time-served sentence. People are shocked by that, but I did run the federal sentencing guidelines, and his guidelines, I'm not sure of them completely because I'm not sure how they're classifying what he was convicted of. There is a upward turn in terms of the guidelines. If he was convicted of engaging in prostitution across state lines or transportation for the purposes of engaging in prostitution, it's actually the Mann Act is actually originally targeted white slavery, the sexual trafficking of women across state lines, but they've revised. Well, they've used it now recently for cases where people are committing these acts for the purposes of prostitution. So they've made it a broader reaching criminal statute. But nevertheless, the maximum there is 10 years on each count. He's not going to serve anywhere close to 10 years. The judge has the option of sentencing consecutively or concurrently. I'm sure the defense will be arguing for concurrent sentence, where the prosecution will argue for consecutive sentences. The prosecutors have indicated they will ask for years in federal prison, but the sentencing guidelines range from, I believe it's as low as 15 to as high as 33 months. Again, it can be consecutive. So hypothetically speaking, if the judge follows the guidelines and goes to the far ends, it could be as high as 66 months, which obviously he'll have 13 months toward that, or as low as 30 months if he runs it consecutive. If he runs it concurrent, I mean, it could be 15 months, or the judge can find mitigation and give him a time-served sentence. So he has a great deal of discretion. The guidelines are not mandatory. There is no mandatory minimum sentencing with regards to these charges. The racketeering did have mandatory minimum sentencing, so he was able to get out from under that. In addition to that, I did put articles regarding some just common things that occurred during the summer months. I put an article today, and also our e-update went out today to over 5,000 of our current and former clients in Pennsylvania and New Jersey. Some great articles typically focused on the July 4th holiday and summer events. I did an article on fireworks. I did an article on the common crimes during the summer months. I'm going to link in these articles that I wrote. I think they're fantastic resources to use. But if you have questions, 215-755-9000 in Pennsylvania, 856-793-7429 in New Jersey, the website GamboneLaw.com. As always, a tremendous resource for you and your family. All of my books, my blogs, my videos are available there. If you are stopped for suspicion of DUI in Pennsylvania or DWI in New Jersey, do not refuse the chemical test. It will never help your criminal case. If police want to search the car, don't give consent. If they're trying to search their car, don't get in their way. Just make clear you're not giving consent. Remember, warrantless searches are permissible in the state of New Jersey. In Pennsylvania, police need a warrant to search a car for the most part, unless there's exigent circumstances or they see contraband in plain view. But again, if just don't give consent, be polite, be respectful to the officer, don't refuse the chemical tests. You can refuse the field sobriety test if you believe you physically can't do the test for whatever reason, because you have some injury or just some limitation. But again, if you have questions, 215-755-9000 in Pennsylvania, 856-793-7429 in New Jersey. Have a great July 4th holiday weekend. It's going to be a busy, hot weekend, I think. It's not supposed to rain. But again, have a great day, have a great holiday, have a great weekend, and I'll talk to you all very soon.